What small businesses should know now and not later. So first, we'll talk a little bit about trademark fundamentals. Key among those is just what is a trademark anyway. We'll discuss the benefits of federal registration, and then I will provide you with some resources should you want to learn more about trademarks. Ordinarily, we have a trademarks boot camp, which is a series of 8 webinars on all of the different aspects of the trademark application and registration process. So that is 8 hours. We don't have 8 hours this morning, so obviously we're not going to touch on everything. But like I said, at the end of this, I'll show you the resources that you can access on your own, should you want to learn more. So trademark fundamentals. What is a trademark? I'm sure everyone here recognizes everything that's up on the screen right now. And when you see these logos and these words, you immediately make an association with certain goods and services. Up there in the upper left, you see the Apple logo. You see the Apple logo, you're thinking smartphones, you're thinking computers, you're thinking personal electronics, peripherals. You see Coca-Cola, you think soft drinks. You see the golden arches, you think fast food. You see Nike, you think athletic apparel. But what does the trademark actually do? So a trademark identifies the source of goods and services, and it distinguishes them from the goods and services of another party. It provides legal protection for a brand. So if the particular matter doesn't identify goods and services and distinguish them from the goods and services of another party, it's not a trademark. I can't tell you how many times someone has come up to me and said, hey, I want to trademark my name, or I came up with this great slogan, and I want to trademark that slogan. And I say, great. So what is it a brand for? What goods and services are you providing under this brand? And I get a blank stare, and they say, well, no, I just don't want other people to use it. I just want to protect it. And I say, well, you might have a great brand name, you might have a great slogan, but unless you're using it as a brand name for specific goods and services, that's not going to be a trademark that you can register. So getting into that a little more, what does a trademark not do? So it doesn't mean that you legally own that word or phrase. It doesn't mean you can stop other people from saying that word or phrase. And it doesn't mean that people owe you money if they say that word or phrase. So for example, if you have a business consulting services and your brand name is Cheetah, you can't call up the San Diego Zoo and say, hey, you guys better stop talking about cheetahs unless you pay me first. So again, that's not what a trademark is. It doesn't give you any exclusive rights to the words themselves. It gives you exclusive rights to use the word or phrase when you're using it as a source indicator or brand name for goods and services. So the 3 most common types of trademarks that we get here at the office are brand names, slogans, and logos. That is well over 99% of what we receive. So, for example, a brand name, Coca-Cola. Slogan, it's the real thing. And then these 2 are examples of logos. You have the seal with the Coca-Cola bottle and the wording, always Coca-Cola. And you also have the logo of the bottle itself. However, a trademark doesn't just have to be, the name, the slogan, or a logo. It can be anything that functions as a source identifier, anything that's kind of a brand. So you have sound, the NBC chimes. For anyone who's under the age of 30 in here and doesn't necessarily watch broadcast television anymore, the Netflix drum at the beginning, the da-dun, that's also a sound trademark. We have color. So if you're sitting in your living room and you see a dark brown delivery truck go by, you know that's UPS because UPS has a registered trademark for solid dark brown as used in connection with package delivery services. Scent and smell can be a trademark. The smell of Play-Doh. So that's the smell of Play-Doh isn't something that's integral to the chemical reactions when you make modeling clay. It's a smell that the company adds in afterwards. So if you're working with modeling clay and you experience that smell, you know, okay, I'm working with Play-Doh from Hasbro. You also have motion and hologram, as well as configuration and shape. You see one of the most famous configuration marks there in the bottom right. That bottle right there, even though it doesn't have any other wording or labels on it, I'm willing to bet that if you saw that on a store shelf, you'd know the soft drink that was inside, and that's Coca-Cola. So these are more just reminders, the knowledge check. So does a federally registered trademark mean that you own the word or phrase? No, no, it does not. You do not own that word or phrase in and of itself. So when you have a registered trademark, what that means is that you have exclusive right to use that word or phrase as a brand name for the goods and services that you identify in your application. So this is one that we get a lot. Do you have to use your business name as your trademark? You don't. You can. A lot of people do, especially when they're first starting out, and they want to kind of lead with their business name as their first brand name. And then maybe they come up with um, additional lines of services, additional lines of clothing, um, whatever it is you're making. As the business expands, you know, maybe you apply for more trademarks then, or come out of the gate with whatever you want to be your brand name. It does not have to be your business name. So there are a lot of benefits to federal registration. You have two ways of creating trademark rights. You have common law and you have federal registration. A question I get a lot, especially from small businesses, is, well, do I have to have a federal registration in order to have trademark protection? And the answer is no. No, you don't. You are protected by common law. You get common law rights the instant you start using uh, a particular brand name, a particular trademark. But there are some downsides to relying on common law trademark rights as opposed to the rights granted to you through a federal registration. So like I said, your common law rights are created the second you start using your trademark in commerce. However, those rights are limited to the geographic area where your mark is used. So if you're using your trademark in business in Georgia and South Carolina, that's the only place where you're protected. So if someone else comes in and registers a trademark for your brand name and they register it federally, they're going to have it everywhere else and they're going to have priority over you. So, you have your common law trademark in Georgia and South Carolina. Let's say you want to expand to North Carolina, you want to expand to Florida. Well, that's no good because that person who came in and got a federally registered trademark now has superior rights to you. So, if you're happy where you're using your trademark right now and you're fine relying on common law trademark rights, you know, maybe that's good for you. If you're looking to expand, if you're looking to have an internet business that touches on more than just the state that you're in, maybe the federally registered trademark is better. Ultimately, that's up to you. That's your decision. It's a business decision, and we can't really recommend one or the other for you. Now, when you're relying on common law trademark rights, you will use the TM or SM next to your brand name when you're using it in connection with the services and goods. You don't have to do this, but this is a way to let people know and put them on notice. Hey, I'm using this as a brand name. This is a source indicator. This is my trademark. None of you guys should be using this. This is mine. But if you don't have the federally registered trademark, you don't get to use the R with a circle in it because that specifically means that you have a federally registered trademark. So the federal registration rights, these are created when you federally register your trademark. And the good thing about this is that once you have that registration, there's a legal presumption that you not only own the trademark, but that you have the right to use the trademark in all 50 states and US territories. And that presumption is great because if there's ever any litigation as to who's infringing on whose trademark, and you have that federal registration, that creates the presumption immediately that you're the one that owns it. And it's incumbent on the other person to show that, they somehow have superior rights. So if it comes down to any type of litigation, having that federally registered trademark can save you a lot of time and money in terms of gathering evidence and making arguments. The other good thing about having a federal registration is that it puts the public on notice of your rights in the trademark. So what we have is we have a federal register. It's and you can access it via a search system that we have. So when people are looking to register their own trademarks, they can go in that system and search and see, okay, well, does someone already have this? And if you've federally registered your trademark, you're going to be in that system, and they'll see you when they search for your trademark, as opposed to if you're relying on common law rights, where that's not going to show up in those in that register. It's not necessarily going to show up when you're doing a search there. You may have to do a more in-depth Google search or some other type of internet search to discover a common law trademark holder. So getting it in there in the register is a good way to get people to turn people off from using what would be an infringing mark before they get too committed to it. And that can save you a lot of hassle. So you also can bring legal action concerning your trademark in federal court. This is good because it's a lot more streamlined. They have a lot more expertise in handling trademark and intellectual property cases. You also can record a federally registered trademark with the U.S. Customs and Border Protection. And what this allows for is if someone is making counterfeit goods using your trademark and you record your registration with Customs and Border Protection, they can seize all of those goods immediately. They can bypass a lot of the administrative hurdles that they otherwise would have to go through, and you would have to go through in order to get those counterfeit goods taken care of. You also can use a federally registered trademark as the basis for filing in another country. So if business is going really well, you want to expand to Canada, you want to go to Mexico, having that federal registration can really streamline the process. So when you have that federal registration, you no longer have to use the TM or the SM. And you can, if for some reason you're emotionally attached to those abbreviations, that's great. Sure, we're not going to stop you. But you are now permitted to use the R with a circle, the federally registered trademark symbol. And when you put that next to your brand name, that sort of puts people on notice that you have that heightened level of protection, that you have a federal registration. So they may need to think twice if they try and infringe on your intellectual property rights. So the quick knowledge check, are you required to register your trademark with the USPTO? No, you're not. But if you don't, then you're going to be relying on those common law trademark rights, which could be sufficient for your business needs, but you aren't going to have quite as many rights. You're not going to have as broad a scope of protection. So does it give you international protection when you register with the USPTO? It does not give you international protection. You have the presumption of ownership and right to use the mark in all 50 states and US territories, but the protection does not extend to foreign countries. However, like I said, your US registration can be used as a basis for filing in other countries, and that can, help speed the process up if that's a type of expansion you're looking to undergo. So this might be the most helpful. There we go. We lost some lights here, so I wanted to help out. How to find help. So these are incredibly useful links. I can send these slides later, so you don't need to desperately copy them down. So beware of scams. Unfortunately, that's the world we live in. if you file your application for a trademark, the information that you include in that application becomes public, to include your contact information. And you have a lot of scammers out there who will prey upon the fact that, maybe you don't have as robust a knowledge of the process, and they can exploit that and make you think that, okay, well, there's these additional fees that you have to pay that you just didn't know about. So you'll get a lot of folks that pretend to be the USPTO saying, we've looked over your application, there's all these issues with it, you have to pay us another $400 or we're going to cancel your application. Beware of that. If it's not coming from us, if it's not coming from at uspto.gov, it is not coming from the USPTO. It's coming from a scammer. So we also have filing firms. And filing firms are companies that try and draw you in with low costs and promises to get you that registration. So a word to the wise, nobody can guarantee that you will get a registration simply because you've applied. Filing firms will make it sound that way. They're just trying to separate you from your money. So there can be misleading notices and offers, all types of solicitations that are going to come in. Some of them are legitimate. It's just attorneys looking to drum up business. There's nothing wrong with the services they provide. But a lot of them, are misleading, kind of like the filing firms. They'll promise more than they can deliver. They'll charge you for things they're not doing. We're trying to get in front of these. We're trying to educate the public, but ultimately, it's like a game of whack-a-mole. The scammers, they're quicker than we are. Whenever it looks like we're one step ahead, it turns out they're 2 steps ahead. So resources for you when you're going through the application process. First, we have our website, www.uspto.gov. This has a lot of fantastic resources on it, whether you are looking for information on patents or trademarks. That's going to be there on the front page. We have a trademarks tab. You can click on that, and that'll bring up a lot of other links that you can go and visit based on what it is you want to know. We have trademark videos. This used to be a lot more robust of a library, but currently they're undergoing an update, making sure that all of the information is accurate and up to date. So there isn't going to be quite as much in there as there used to be, but there's still good information in there. And finally, the Trademark Basics Registration Toolkit. I highly recommend checking this out, especially if you're early on in the process. If you're trying to decide whether or not you want to apply, if you're trying to decide what your brand name or trademark should be, if you want to know some of the common pitfalls that befall applicants when they're going through the application process, this is a fantastic resource to give you an overview of all of that. And I spoke earlier about the Trademark Basics Bootcamp. This is another one that I highly, highly recommend. So we actually just finished this quarter's series, but it is once a week. There is a 1-hour presentation on various aspects of the application process. We have week 1 is an overview. We'll move into conducting clearance searches, and that's when you go into our system and search to see, well, what's already been registered? What might pose a problem for me if I apply for this particular trademark? We actually run through the trademark application itself, and we've had people attend these boot camps with their laptop next to them, watching the desktop presentation, and they literally fill out their trademark application step by step with us. And at the end of that lesson, they hit enter and they filed their trademark application. So a lot of good information there. At the end of the sessions, there'll be a Q&A portion where you can ask experts in real time questions that you're having about the process, about the law, about any sort of thing. So that's a fantastic resource if you're looking to get information on the process. We also have the IP identifier. This is interesting if you don't know what it is you have. You have some type of intellectual property. You click on this, it'll ask you some questions, and then at the end of it, it'll spit out, well, hey, based on what you've told me, you're actually looking for a patent, or you're actually looking for copyright, or you're looking for a trademark. So it's a really good first step if you're really, really, really early in the process. Right here, we have free services and resources. If you go here, it will provide you a list of, well, free services and resources. Chief among them, law schools often have clinics where for uh, sole proprietorships or small businesses, you can apply for free assistance with the trademark application process. And what will happen is a law student, under the supervision of an actual attorney, will go through your application. They'll talk to you. They'll figure out what it is you want, where you want to go, um, and they'll help you through the process. They tend to be very successful. We get a lot of good feedback on those. But each law school is going to have different criteria that you have to meet. If you're interested in that, I'd recommend going there and doing a search and just seeing what's close to you and what you qualify for. We also have the USPTO Virtual Assistant. This is currently in beta. Um, it doesn't answer a lot of questions, but it has a number of them. You can ask it questions and then it will give you answers in return. And it's free, so there's no harm in playing with it. So finally, the Trademark Assistance Center is the main support center for all trademarks customers. So if you have questions about the process, if you have procedural issues that are going on with your particular application, they can help you out with that. They respond quickly to both calls and emails. Your choice, whether you want to call or email. They cannot provide you substantive advice. So if you say, hey, I applied for the trademark, the examining attorney sent out an office action and they refused it, and they said, I have to give them this other stuff, what should I do? That's not the type of question they can answer. So like I said, the USPTO, we cannot provide legal advice. We do not enforce legal rights. So when you get that registration, it's going to be incumbent upon you to constantly be searching and monitoring to make sure that someone else out there isn't infringing on your rights. Now, if someone comes in and applies to federally register a trademark that is confusingly similar with yours, we're probably going to catch that and we're going to refuse them. So, we do perform that function, but in terms of the actual enforcement of the rights, that's going to rely on your diligence. We cannot recommend specific private attorneys as much as we would like to. Examining attorneys, all of us have we've seen who does a good job and who doesn't. And as much as we would love to tell you who's doing great and send you their way, that's not something we're allowed to do. And that is the end of the presentation. Like I said, we didn't cover everything, but if you access those resources there at the end, you should get a pretty good coverage of the issues that surround the trademark application and registration process. I don't know if we have time for questions.
Yes, Kyle, we should have time for questions. So if anybody has any questions, please drop it in the chat, and then that way we can just control the flow of the questions being asked, so we can get through them pretty quickly. As you guys know, this is our economic impact call. We do normally end around this time, but when we have a speaker, we usually go to 9:30 or 10, depending upon the questions. So if you have any questions for Cal this morning, go ahead and drop them. But then Cal, this is a great presentation, and I like the fact that you even brought up about using someone's services for trademarking. I always remind people that, hey, every office has actual employees, and so you can just go to them and ask the questions
Yes.
and get your trademark done yourself. But I understand if you don't have the bandwidth, or if you just feel comfortable going to a lawyer or legal professional or someone that's in that realm as being a consultant, that you can also hire someone to do that. So I just think that was a good point that you made. And then I don't know if you can drop in the chat how they can sign up for I think it was the sessions you have on a weekly
Yes.
basis. So
Yeah.
that way they can participate in that. Let me see if we have any questions. Oh, that's a good question. And then I'll let you drop in the chat, then I'll start asking some of the questions, Cal.
Boot camp. I'm pulling up the link now. So I can actually send you a collection of links later if you
Okay.
wanted those, and then you can distribute them.
Yep,
But
I'll
I will.
distribute to everybody that's on our email list and contact list. So if you're a member, you'll get
Perfect.
that information, and then our non-member list too.
So I will put the chat here.
Okay.
Okay, so that is the Trademark Basics boot camps, and that'll tell you when the sessions are being held, as well as the subject matter of that particular session. Um, a lot of people attend all of them. Some people just sort of pick and choose, like, hey, I want help with searching, so I'll go to that one. So you're able to continue to use your name if someone else trademarks it. Yes, you're certainly able to continue to use your name. So all that trademark is going to do, if someone who has the same name as you do, they trademark it, uh, they are going to have the exclusive right to use it as a brand name for those specific goods and services. So, if someone comes out and they trademark Kyle Ingram for t-shirts, well, I certainly can keep using my name in whatever capacity I want. I just can't start up a t-shirt company and use Kyle Ingram as the brand name. So that's going to be the difference between normal usage and having a registered trademark. So don't worry. If someone trademarks your name, like, you don't have to change your name or anything. We see that sometimes where someone is under the impression that when they trademark something, they own all the usage of it. I've seen people come in for trademark applications trying to trademark barbecue sauce under the impression that, if anyone
Barbecue
ever
sauce under the
uses
impression that,
the,
if anyone ever.
we're getting some feedback here.
Yeah, let's get some feedback. I'm not sure.
Okay.
Okay.
Yeah, under the impression that anytime someone uses the word barbecue sauce, they owe them money, and that's not how that works.
Okay.
Okay. So
And the
April, I see
next
the second
question
part
I
of that. Oh,
seen,
sorry.
John, from John Williams says, does the trademark cost annually?
So there is no annual cost. Um, what you have an upfront cost of the trademark application, depending on whether you're currently using the trademark, or you have a bona fide intent to use the trademark. So you can actually apply for a registration before you're using the trademark. You just have to intend to use it. But everything is paid up front in the application process. There are maintenance fees that come into play 5 to 6 years after your registration, and then between 9 and 10 years after the registration, and then every 10 years after that. So those are the costs that are associated with it. There's no annual fee for it.
Okay. And then Edward Williams says, is there a local office? We're in Augusta area, Augusta, Georgia area.
I actually don't know where the local office is there. I think they're they're talking about putting one in Atlanta. That's one I'll have to get back to you on, so I apologize.
Okay. And then Janice Jackson asks, regarding slogan, does the slogan have to be in the use and associated with your business before seeking trademark registration is one question.
Perfect. And I think I accidentally just hit on that when I said no, you don't. You have a Section 1A is when you're already using it. Section 1B is what's called intent to use. And that's what you file if you're not using it yet, but you're going to be using it within 3 years.
And then
So, yeah.
Number two is, what is the difference between a copyright and trademark?
So a trademark protects your brand name. It's the source indicator. A copyright protects a creative work. And I think what you're getting at here is a good point, in the sense that sometimes things can be both. If you have this, really amazing artistic creative design, yeah, that's a creative work that can be protected by copyright. But then you also want to use that as your brand, as you want it on like the hang tag of shirts, so that when people see it, they know it's from you. That's going to be trademark usage. So it can be both. One of the examples I like to use is like Super Mario. Super Mario is a creative work. They made the little plumber guy. He's got the red shirt and the blue overalls and the hat. But over the years, Nintendo started using that as their trademark. So it's not about Super Mario anymore. If you buy a video game and it has a little Super Mario in the upper left-hand corner of the box, you know that's a Nintendo game. Again, that's a copyright and a trademark together.
April had asked a question earlier about can she still use her name if it's trademark, but she wanted to make sure she clarified that that was for business name.
So
I
the
don't know if it
business
make a
name,
difference.
what you're getting at here is a likelihood of confusion. So what we do at the USPTO when we see an application is we evaluate it for a likelihood of confusion. And that is, it's a two-pronged analysis. The first is, okay, we've got a registration over here and your application over here, and we compare them. First prong, are the marks similar? Do they look the same? Do they sound the same? Do they have the same commercial impression? And then if they do, we go on to the second prong, and that is, are the goods and services related? And what that means is, are there businesses out there that tend to provide both the registrant's goods and services and the applicant's goods and services under the same brand name? So, I mean, you can think of examples where identical trademarks coexist on the register, simply because, again, those goods and services aren't related. Dove for chocolate and ice cream, Dove for soap and shampoo. Now, do manufacturers of soap and shampoo typically make chocolate and ice cream? No, they don't. So, those can coexist on the register. So if someone has already registered what you want to be your business name, that doesn't necessarily mean that you are blocked from registering that. You would then have to look at, okay, well, what goods and services are they using that as their brand name for? And what goods and services am I going to use this as my brand name for? And if those are not related, well, then you should still be able to register your trademark.
Okay. And then next, I got two more questions. So Candy said, should you keep an idea private until the trademark is approved, or does using it under the common law protection strengthen the application?
So I think I want to dig a little deeper in terms of what the idea, like what is meant by idea. I mean, is this like a business idea? Is this something that like an innovation, like an invention? Um, because that it sounds like we might be getting into like patents. But
And Candy, I don't know if you can unmute and just say real quickly, clarify for Cal to answer your question.
Sure. And that clarification about business idea or innovation is really good thought. So it's a goal setting system, like
okay,
SMART goals, but it's a different acronym. So I
okay.
guess it will fall under a business idea and could possibly be a patent, but would also cross over to copyright as well if it's in like a workbook format or that type of thing.
Well, I mean, nothing I say here is legal advice, but it sounds like you have a business idea, and you know the brand name that you want to be using with that. Is that correct?
Yes.
Okay. So when you identify the goods and services in your application, because every application, I mean, again, you have to be using your brand name or the trademark with goods and services for it to be registrable. So when you identify the goods and services, what we want at USPTO is the most generic explanation of your goods and services possible. And that's good news for you because you're not having to put the secret sauce out there in the public for everyone to see. You don't have to tell them necessarily how all this stuff works. You could say, I'm just spitballing here. Downloadable application software for organizing business functions. Now, that doesn't really get to specifically like how all the nuts and bolts of this works, but it does tell us what you're doing, and it puts the public on notice of how you intend to use this mark. So you don't necessarily have to like reveal the nuts and bolts of your business in the application itself. So in that regard, maybe it's better to go ahead and apply and get your place in line for that registration, and get that higher level of protection earlier rather than waiting. Or, I don't know, maybe you do want to wait. Maybe you don't want to spend that money just now. Maybe you do want to see how that the business model actually works. Those are going to be business decisions, but I don't know. I think, did that get at it? Did that answer the question?
That did. Thank you. Just
Okay,
one more follow-up question to that.
sure.
Would it be more of a trademark or a patent in the sense that it's an idea for a framework?
So I'm not really the patents person. I know very little about patents and can't advise on that. Um, I do know that one thing that we see a lot of is if you are using existing software to just do something new, that tends not to be a patent. If you've come up with software that has a brand new functionality that no one's ever done before, um, that tends to be a patent.
Okay, thank you.
Okay. Then we got one more question, Cal. Thank you for sitting back with us.
Yeah.
I filed to trademark well, it's like they failed, sorry. They trademarked their business name Soka Vegan, but had to abandon the application. There was an issue with the word Soka, I guess, in our service provider, with the word being similar with another business, also a Caribbean restaurant in another state. The other business is Eat Soka, but they claim to have trademark Soka. How to get free help assistance to complete the application process because the input required in the argument seems to need legal jargon.
Okay, so it sounds like you applied, um, and you got an office action with a 2D likelihood of confusion refusal. And in that, they kind of articulated all the legal arguments and provided the case precedent for why this couldn't register. If you want assistance with that, a lot of small businesses look at that and they say, well, I don't understand the legal arguments I need to make against this. That is when you would either need to hire an attorney or in that slide that I had, I don't know if, am I still sharing the screen
It's
of the
not up right
slides?
now, but now we can see it.
Okay. So if you go to the free services here, you can potentially find a law school clinic that could help you free of charge. Um, a lot of times there's a waiting list for those. And if you've already gotten that office action, you have 3 months to respond. You can add an additional 3 months to the response time for an additional fee. But I mean, if there's more than a 6-month waiting period on that, then that may not fit your timeline and you might have to hire an attorney. But that is the only free help and assistance in terms of legal advice, because you're in a situation that requires legal advice. I mean, that's not something that we can, like, that we're permitted to provide you advice regarding.
Okay. Thank you, Cal, for that presentation and answering those questions. We got a lot of questions this morning, so I'm just so happy everybody's getting educated and getting their questions answered. So, Cal, how can they reach out to the USPTO? Any final thoughts or words before I get ready to close out the call?
So regarding trademarks, you can reach out to the Trademark Assistance Center right here. That is what I would recommend. They are fantastic. We work with them a lot. They can get your questions answered, and if they can't answer them regarding trademarks, then they will point you to the people who can.
Okay. Well, thank you so much for that great presentation this morning. And thank you to your team for being on as well and dropping a lot of links in the chat. So I will share out this information with those who registered for any of our calls. Somebody had asked that question. And then also, of course, our members will get the information as well. So that way we'll get this presentation over to you. Once Cal sends it over, we'll get it out to you next week. So thank you, Cal, again.
Well,
And I'm
thank
gonna
you for
get ready
having
to
me.
close that call.
Always nice to help.
Thank you. So I'll go ahead and get into our 15 minutes after. So we have any leaders from the coalition on the line, or any members on the line, or any leaders from GABCC on the line that have any updates. I'll turn over to you this morning.